Hello.
Like we've
Good
got
morning.
Ben Stevens and Adam Hopkins on the line. Is
Morning,
that
Judge.
right?
Yes,
Yes,
sir.
Adam, how are you?
doing all right. Could be better. How about you?
You're muted. You're gonna have to fix that.
All right, 1 second. I'm about to get my caregiver to help.
Ben, you're in Dallas, is that right?
I'm in
Houston?
Houston. Yes, sir.
Houston. Sorry. Yeah, I saw that. Hello, Adam.
Yeah.
How are you?
I'm doing okay. Could be better, but I'm still alive. That's what matters.
Above ground. Now, I saw that you filed a motion asking for some Disabilities Act accommodations, and so we're doing this Zoom. But for purposes of right now, do you have somebody with you today that's helping you do anything?
Yes, my caregiver's here. I'm completely blind, so I got to have my caregiver's help.
Okay. I've read. No reason to wait 2 more minutes. Let's get started. I've read everything that's been filed, and I've got a few. I've got a few questions to start with, as is my practice. It seems like there should be an easy way to resolve this, which means that there's some reason why it can't be done. I don't know. I understand the county turned over some documents pursuant to a Freedom of Information Act. The county then asked for some or all of them to be returned. And Mr. Stevens, can you clarify for me if Mr. Hopkins simply received a notice that says we're snapping some of these back, or if you identified specific pages? How did that snapback request come?
Yeah, the snapback request came from the public information officer for the county, Ms. Jenna
Okay.
Fortenberry. She
What did it
she
say?
she informed Mr. Hopkins that confidential information had been provided by mistake.
Okay.
She informed him that it is a criminal offense to possess confidential information, and because it is an offense, asked that he confirm that he had deleted and destroyed the confidential information he had received.
Okay.
Since that time, he's been provided redacted copies of the same information with the confidential information removed.
Well, we
Okay.
still haven't
So
received all of
if
them.
you took hang on, Mr. Hopkins. So if you put side by side the package of documents that he received unredacted and the package of documents he received redacted, then you could identify which pages you were asking to be destroyed. Is that a fair summary of your ask?
I think that's correct. I think at this point, I think what we would suggest is the easiest way for Mr. Hopkins to do it is just get rid of everything he got from us originally
Yeah.
and keep what he got from us recently.
Right. So
Because what
those
we
are
got,
so those are my two questions of you, Mr. Hopkins. Is there some reason that you can't take everything you received the first place and just throw it away, or at least put the documents side by side so you can identify the ones that came to you the second time with redactions and throw those away?
Well, it's going to be hard for me to do that because they still have yet to send it in a screen reader format, and we took the files all down, and really the way that Jenna Fortenberry had responded to me, it felt like she was trying to incriminate me over files that I received during a public records request, and I asked
Yeah,
her
I
to
can
be.
I can see why. I can see why to a layman it might have felt that way. I when I read what I saw, it felt like first of all, nobody says that you're at fault for doing anything other than receiving documents that shouldn't have been sent, and I think the county has said as much, and the county has said, here are the documents that you should have been sent. And so then you're receiving a notice from a public official that says, now remember, don't be careless or reckless with the documents that you shouldn't have received. And so there's ramifications if you mishandle those. Please throw them away. And so far you've just been told kind of where you stand, and asked not to misbehave, I guess, with respect to those documents. So I'm trying to cross the easy bridge first, which is, how could you go about complying with the request to destroy the documents that you should not have received? How do you do that?
Well, I restricted the links that they had sent me, and now I have a new phone, so I didn't even got the old files anyway. But because like they had put a block on the link anyway that they had sent me, to make it where we couldn't access it. But I don't know how to go about getting all the other files that have been seen by the public. Because like I was under the impression they were public. It was a public
Understood.
information request. And I rely on volunteers to get this stuff read to me. And next thing you know, I'm getting a message from that message I guess you've seen from Jenna Fortenberry. Um, pretty much demanding me to take them down. Saying that it's a criminal offense if I don't, um, and I had no way of reading them myself anyway, because like every public information request I do, I request through the ADA that they make that accommodation where it can be in a screen reader format, and not a single one of them have been sent in a screen reader format. Even the new ones that they had sent back, and we're still waiting on a bunch of them. And Jenna Fortenberry acknowledged that there's still more files that they're working on, and she said something about it was going to take 10 to 14 more days, and that's been uh, way overshot. Like, that's been like 2 months ago now. So,
Yeah, understood. I hope you understand that's probably that's not something that I will be dealing with. Um, my jurisdiction has been invoked through a declaratory judgment lawsuit that you filed, and those are my issues. So if there's some failure to comply with a Freedom of Information Act request, that's kind of not really on my plate right now. So don't expect to hear me say anything to Mr. Stevens, directing that. I noticed that the new documents that came had redactions in them, and so I will observe. Tell me if I'm wrong, that your reader system can't read something that isn't words if it's just a black square, and so I don't have an expectation that you're going to be able that sending you documents in the format that's read by your system isn't something that's going to solve this problem, because a properly redacted document you can't read anyways.
yeah.
Okay, I think I heard you say that there are things that you have posted or published that may include the documents that
That's
may include
how,
documents that contain.
that's how Jenna Fortenberry ended up reaching out to me, because I guess somebody had shared the files and it got out there. And so after Jenna Fortenberry reached out to me, I restricted them and took the files down.
Okay.
Um,
Mr. Stevens, do you have any particular knowledge about whether there's anything out there that is a continuing threat to third parties' privacy?
Our understanding is that the confidential information was publicly posted. It has been taken down. We do not know the extent to which it was, screenshotted, downloaded in the period it was up. But at least as of right now, our understanding is that Mr. Hopkins is not publicly hosting any of the confidential information, and we're satisfied with that. I think our concern is still that he may have some of it. We just ask him to hit the delete button on it and replace what we previously produced with the redacted copies we have since produced.
Um, it sounds to me like, from what he said, that he's done what he could. With his comment about I've changed my phone and I don't have the documents themselves anymore. Anyways,
I heard that as well, and we appreciate that.
I'll take that as good as a delete. Which leaves me with this position, Mr. Hopkins. You have filed this declaratory judgment action that asks the court to do a number of things, and I want to go through the list with you just to make sure I understand. I think I do. But what you've asked for, you want a declaration that your voluntary release, that the county's voluntary release waived any confidentiality claim. I'm not going to do that, and I can't do that. An accidental release of confidential information is not a waiver, and so I don't blame you for asking, but we already know that it doesn't. So I can tell you that that one's not a claim. The second, that plaintiff bears no liability because you acted in good faith. Now, I don't blame you for asking that one either, but there's a concept in the law called ripeness, and it's just like it sounds. You wouldn't pick an apple before it was ripe. It's no good. Same thing with the law. You can anticipate an issue, but if it hasn't actually come up yet, there's nothing for a court to do with it. It's like asking the court to issue what's called an advisory opinion, where I tell you what your rights may be going forward. That would be me acting as your lawyer, not me acting as your judge. And so when I have an issue in front of me that is not ripe, namely whether you are liable for something that has happened, there's nothing for me to do. You've been advised of what the statute said and what your rights are in that correspondence from the clerk, but there hasn't been a claim made against you, and there hasn't been any exposure to liability. And the issue of whether you acted in good faith sounds right, but we haven't taken any evidence, so I would say that claim is not ripe. The third one is the county bears any breach notification obligation triggered by its release. And that may or may not be so, but that's not a claim for you to make. That would be a third-party defense if you got sued. And then number 4, plaintiff may lawfully retain private copies as evidence for defense of his rights. That I can tell you right now that you're not allowed to retain confidential information that was sent to you in error. And it sounds like that you've indicated to the county that they've been deleted anyways, and third parties can't get them. So I think you've gone as far as you need to. And then the last one was defendant must provide accessible, properly redacted replacement copies, which they've done. And so what I'm saying by going through these things is that it sounds like by your good conduct and by the county replacing the documents that there's nothing left of the lawsuit itself. That's what Mr. Stevens' brief basically said. I'll tell you, as a almost 50-year lawyer, I could see it anyways on my own, but I appreciate the brief. But anyhow, Mr. Hopkins, I wanted to make sure you knew that I had read exactly what you filed, and that it appears to me that this issue is all kind of resolved, and you don't really have anything that you can or need to do until something negative happens. You get sued by somebody, or you get prosecuted by somebody for releasing the information, and at that point, then your suit, if you have one, is ripe. But right now, it's not ripe. Mr. Hopkins, do you have any thoughts or questions or concerns about that? Do you understand what I've said?
Yeah, I understand what you said.
Okay. Mr. Stevens, you provided me with an order that called for a dismissal with prejudice. And I think I'm inclined, unless you talk me out of it, to indicate without prejudice, because if I say with prejudice, it sounds like I've pre-adjudicated a non-ripe matter. Does that make sense?
I'm not opposed to the dismissal without prejudice, Judge.
Okay. My intention is to sign the order dismissing the case without prejudice. Mr. Hopkins, without prejudice means you can refile it if you need to, if and when the facts change, namely if the case becomes ripe. I hope I've described
Like if somebody
ripeness.
decides to try to sue me because of that information that was released that shouldn't have been.
Yeah, if somebody then actually sues you, then your claim will become ripe because something will have actually happened. I don't have the authority to preemptively tell anybody that they can't file a suit. Certainly a third party, like, Mary Smith or Joe Blow decides to sue Anthony Hopkins, Mary Smith and Joe Blow aren't in front of me right now. I don't have any jurisdiction over them. I can't tell them what they can and cannot do. It's only when they come in and file a claim and they invoke the jurisdiction of the court, as you have, that I would have authority then to say, no, Mr. Hopkins is not liable because he acted in good faith, or no, the liability is actually with the county because whatever you want me to say about them. That's what I'm trying to explain to you about ripeness. And I'm saying right now that your case, as you filed it, is as to a couple of items, it doesn't state a claim because I can't do what you asked me to do. And as to the other ones, it's not ripe. Okay, are we good? Anybody else want to say anything? No?
No,
Mr. Hopkins, perhaps our paths will cross again in the future. I'm a visiting judge. I guess I got appointed because your suit was against the county, and so they grabbed somebody from another county, and that's me. And so I can't say if you file something, if I will or will not be your judge, but nothing more fun than being a judge practicing, in Texas. So I hope I get to. God bless you. Have a great rest of your day, Mr. Stevens. I'll sign your order, and we are off the record. Thank you all for participating.
Thank you, Your Honor.
Sir.
Thank you, Mr. Hopkins, for your time.
Thank
Good day,
you.
all.
All right, you